Good evening and welcome to this event in the series of events under the title Social Context of Law. In these events, we consider contemporary issues that are always difficult, always involve the law, and are sometimes controversial. The subject of this evening's particular event, talk, discussion, debate, is considered by some to be the very most important of all difficult events in a modern world, and my goodness, there are plenty of them for us to consider, because to those who take that view, you're dealing here in what is happening or not happening to the environment, and with what is done or not done by governments, with something that is existential so far as the planet itself is concerned. And it may be, although we'll hear more from the experts, and I am no expert at all in this field, some people probably think that it is so important, so critical to all of us, that the law does not need to be followed. The structure will be explained to you by our chair, who I will introduce to you in a minute, but just one other thing, or two other things from me at this stage. When we come to questions and answers, I'm afraid we have a rather strict protocol. Prepare your question or possibly comment in your head so that it doesn't last more than 30 seconds. If it does, you'll simply be shut down. Please don't thank the speakers, it's slightly patronizing, and don't introduce yourselves. It's not because we're not interested in you, we're just not that interested in you. And we are rather more interested in our speakers. And if we proceed in that way, we get much more from them and really useful contributions from you. And if there are students here with 30 seconds prepared, they will be given first chance to ask questions or make comments, provided they are the allotted 30 seconds long. When the event is over, there's a reception outside, and because grandees such as our panel are quite likely to gather together, we separate them out and tether them to tables where they're given a drink. And they've got the name on the table in case you've forgotten it. And that means you can go and speak to them and make your points which you didn't get round to making beforehand. So that's all from me, save that it's my real pleasure to introduce the moderator, Master Saira Kabir Sheikh. Now, I could give the long CV. She's an eminent silk in planning and all sorts of other laws. But what's important for you is that she has been involved in prosecutions and defenses of people charged with criminal offenses concerning protesting on environmental matters. So that puts her in an ideal position in the middle of the table to introduce the two other speakers.
Thank you, Sir Geoffrey. Well, welcome everybody. And I am, as Geoffrey says, I'm going to be moderating this discussion today, which will hopefully be lively and thought-provoking. We are talking about, as you know, environmental law, regulation and the right to protest. And we've got two panelists who are leaders in their fields. And I'll just introduce them first before just setting out the parameters really of our discussion. So we're going to have Stephen Simblet, who sits here to my left, King's Counsel. He is a bencher of this inn, and he's also joint head of Garden Court Chambers. He has a practice that focuses mainly on individual rights, civil claims against the police, inquests, mental health, and the like. He's also been one of the lead advocates in the Hillsborough inquests representing bereaved families. However, for today's purposes, you just need to know that he has been representing protesters. He appears, I think, only for protesters. Yep, he's so far, yes, he acts for protesters, and he's been involved in numerous cases relating to court injunctions taken out by commercial organisations, basically against protesters, so stopping them from protesting. That being the purpose of these injunctions. He's been involved in lots of High Court cases. He's been very successful as well in having some of these injunctions stopped. And he's also been involved and is in the centre of cases relating to opposition to fracking. And our second panellist here on my right is Sudhanshu Swaroop, King's Counsel. He's at 20 Essex Chambers. He has a practice in commercial law and international trade, energy and natural resources. He has, however, developed a very strong practice in relation to climate change, and he is a true expert in that area, having been involved in some of the major international cases which have attracted worldwide media coverage. He has lectured extensively on climate change law as well, and he's been involved in some of the landmark cases, including cases relating to issues relating to rising sea levels in Australia and the failure of that country to protect some of the islands. So we have got, as I said, we've got two leading members of the bar who are well placed to deal with the issues. So insofar as the structure then is going to be as follows, we're going to have the two panelists speak for about 10 minutes. Then I will pick up some points from their discussions, ask them some questions and ask them to comment on them, following which we'll have the Q&A, and you've already heard from Sir Geoffrey how that's going to go. So far as the areas that we're going to be discussing, well, climate change and environmental catastrophe are real and pressing issues. They are the issues really of the day. But there is nonetheless a view that protests need to be within the boundaries of the law and to respect the rights of others who are also entitled to exercise the rights that have been given to them in a democratic society. So what we're going to do is to explore some of the recent decisions of the courts. We're going to look at the civil and the criminal courts. I would expect that we're going to talk about Articles 11 and 10 of the Human Rights Act and look at perhaps the way that that's been dealt with by the courts. We're going to also look at whether or not the law corresponds with what is just, whether or not there is anything that needs to be said about the recent legislation, the Public Order Act, and how that impacts on protest rights and perhaps the impact that it has rightly or wrongly on the Article 10 and 11 rights to protest and the rights to assembly. And we're also going to cover the question of civil injunctions. Have they increased? Should they have increased? Are they being used more frequently? And if that's so, is it fair? And how those injunctions are being enforced through committal proceedings. So overall, we should be having a discussion considering whether the right balance is being struck in relation to the right to protest and the interference with those rights. So without further ado, if I can turn to Stephen.
Good evening. Well, first thing to say is that very few of the rights and freedoms that we all enjoy would have occurred without some form of disruptive protest. We celebrated the anniversary of Magna Carta that much longer. Well, that was the product of armed confrontation between the king and the barons. We're sitting in the Inner Temple, one of the places stormed by Wat Tyler in the Peasants' Revolt, where it was burned. Subsequently, the serfs gained more freedom. The poll tax was abolished, and we didn't have another poll tax introduced until Margaret Thatcher tried it in 1990, resulting then in a series of demonstrations and protests, nearly every window in Trafalgar Square broken, and the poll tax defeated. The planning for this talk we met as a group took place in the Gandhi room downstairs, which is a room, of course, commemorating a man disbarred by the Inner Temple for his actions campaigning successfully for the independence of India by disruptive protest. Even basic democratic rights, such as voting, came about through disruptive protest. The extension of the franchise introduced in the Reform Act 1832 followed riots across England in 1831, and it's only just over 100 years since women had the vote, and that was brought about through disruptive protest. The suffragettes had a window smashing campaign, and they also disrupted sporting events. Everyone's heard of Emily Davison throwing herself under the King's horse at the Epsom Derby. The suffragettes also attacked perceived male environments such as football grounds and golf courses, where they replaced flags with suffragette colours or would carve messages in the greens, damaging them. There was similar disruption to sporting events, including rugby and cricket test matches in the 60s and 70s by anti-apartheid protesters. Those things were all hated at the time, just as Just Stop Oil throwing orange dust over the snooker tables at the Crucible in the World Snooker Champions got the same sort of criticism. But sitting here now, who would say women shouldn't have the vote, or that a country that categorises people by race and prevents the majority of its population have any sort of rights should be welcome in the UK? But those positions came about, it seems, in large part, not through cases brought in the courts, but through disruptive protest. And it's in that context, I say, that we should be considering the specific topic that we're asked to consider here, which is the climate change and environmental catastrophe as real and pressing issues. The question is whether to what extent the law corresponds to what is just. Sudhanshu may cover some of this in a moment, but there is a Climate Change Act 2008, 15 years ago. Over 5 years ago, the House of Commons unanimously passed a motion declaring a climate emergency. But here we sit in 2024, still facing that climate emergency. And there are some people who would say that very little of substance has changed, and it is largely by protest that things will be changed. Now, Saira has said that we'll touch on the Articles 10 and Article 11 of the European Convention on Human Rights. It's probably since the Human Rights Act was brought in came into force in 2000, that there was the sort of heyday of protesters' rights being perhaps respected more in the courts, and the balance being struck in a way that I would say is being struck quite differently post 2022. I'll come to that in a moment. But Article 10 gives you the right to freedom of speech, and interference with that can only be done for a range of very limited exceptions. Article 11, freedom of association. Those are important things because from a protest point of view, the difference between a crank with a one-person campaign, such as the man who used to walk up and down Oxford Street with his sign up saying "Don't eat nuts" or something, and a real social movement is numbers. So numbers and presence of numbers and the location of a protest are all very important things. So when we're looking at how protest rights are to be considered and what limitations there should be on those from the law, we have to bear in mind that the symbolism of a protest and the numbers of a protest are what's important, not just what is said. In a case from 2007, I think it was, Crown and on the application of Tabernacle against Secretary of State for Defence, a protester challenged the existence of bylaws prohibiting access to land outside the Aldermaston base, where the purpose of the bylaws was to deter protest. She failed at first instance in her challenge, but succeeded in the Court of Appeal, where Lord Justice Laws, the year before he became Treasurer of this Inn, said, and it's worth reading this at paragraph 43, "Rights worth having are unruly things. Demonstrations and protests are liable to be a nuisance. They're liable to be inconvenient and tiresome, or at least perceived as such by others who are out of sympathy with them. Sometimes they're wrong-headed and misconceived. Sometimes they betray a kind of arrogance, an arrogance which assumes that spreading the word is always more important than the mess which often literally the exercise leaves behind. In that case, firm but balanced regulation may be well justified. In this case, there's no substantial factor of this kind. As for the rest," and then it goes through whether the activities were, the cause was valid or not, he said, "The Secretary of State's shoulders are surely broad enough to cope. And that position informed much of the way in which the law developed through the 2000s. But as things have moved into the last decade or so, a number of things have happened that make things harder for protesters to get their message across. One that's been mentioned already by Saira is that it's not just governments, but private companies who are resorting to law to try and suppress protest against their activities. So private companies whose profits are jeopardized by the objective that protesters wish to achieve find it useful to appear to bring their own proceedings for civil injunctions in the courts. Now, there used to be a number of procedural difficulties for them there. For instance, it was expected they would get properly named defendants before the courts. In one case, the cases I did in 2005, EDO against Campaign to Smash EDO, the claim against the unincorporated, it's a good title, isn't it? The claim against the unincorporated association Campaign to Smash EDO was struck out. The court would only proceed against named defendants. But that position has changed and has been in the courts quite recently to allow people to bring proceedings against unnamed defendants. And that provides a very considerable advantage to the claimant, because it's the claimant, the company, that has the time on its side. It decides what it wants to put before the court. It applies the court with a relatively low threshold, an annus minute threshold of showing an arguable case, brackets, if it's something that affects rights under Article 10, the threshold moves to showing that you're more likely to succeed, but it's still a relatively low threshold, and a balance of convenience test. And it's the company that chooses the procedure. So quite often they will go ex parte to court. So they're going ex parte to a court, seeking an injunction that affects everybody, essentially now against the whole world, which allows them essentially to construct a case against an entirely theoretical defendant, essentially the bogeyman. If this doesn't happen, people will come round and set up a camp here or do this, that, and the other that we don't want to happen. And while, of course, on any application of that sort, there's an obligation to inform the court of the contrary arguments, it's quite difficult for that to be enforced or as considered as thoroughly as it might be, for reasons of listing, for reasons of time. For instance, in the Ineos case in which I was involved in, the claimants proceeded in secret because they didn't want to tip off the defendants. They didn't inform the court on the claim form that the claim involved claims under the Human Rights Act, which probably had an effect on where and how it got listed, and where all they told the court about the human rights arguments was there was a case that said Article 10 ECHR was not a defence to someone squatting in a building as part of a protest against possession proceedings. Not an unsurprising proposition, you may think. But what they were seeking in that case was extremely wide-ranging and draconian injunctions. That was the language the widest ranging injunction ever sought was their own press to the Financial Times after they'd got their injunction. It had a vast effect on all sorts of people involved in supplying the claimants, their supply chain, the contractors they would use, all sorts of things, and very great uncertainty. And that injunction stayed in place in its entirety over 4 months. Some of it was discharged at the end of those 4 months, and most of it, in fact almost all of it, discharged by the Court of Appeal in 2019, over 2 years after it had been brought. So people get their injunctions, and people opposing injunctions take on a very considerable risk to themselves. There are risks of costs. In Ineos, virtually every letter to the claimant solicitors result in letters back threatening vast sums in costs. And even people who feel that their ordinary life is going to be very disrupted by whatever it is the company is doing. So in the fracking injunction cases, basically people drilling, turning the countryside into industrial usage if it's fracking, something, say, the size of a football ground being put in a rural area, you can see why a number of people would be extremely exercised about that. And it's worth remembering that these injunctions bind us all. You may not know that you're the potential defendant to an injunction brought by Transport for London, or for the Thurrock Council, or for the Essex County Council, but there are currently injunctions in place all round various sites in London, in Essex, North Warwickshire, and have been brought mainly with the support and encouragement of energy companies, because it's in their interests for protests to be deterred. I mean, it's in anyone's interest for protests to be deterred. If somebody disagreed with me, I'd rather they had less of a platform to disagree with me than more of one. That is to some extent common sense, but the courts have some people would think played a greater role in building up a number of restrictions on protests than might have been thought. The fact that it is an injunction sought against the world is, in my view, a real and current practical problem. These injunctions are often sought on a quia timid basis, so before anything has happened, and the court, therefore, on an ex parte hearing, is unlikely to be able to pay much attention to the weight of the real threat or the weight of the contrary evidence, even on the relatively relaxed test that's being brought. For instance, in Shell and Persons Unknown, where there's an injunction that prevents people doing various things that you may well understand would be prohibited, such as trespassing on Shell's headquarters, but also prohibits people demonstrating at petrol stations, any petrol station in Britain that's got anything to do with Shell. That injunction sits on a pleading of conspiracy to injure. The pleading doesn't say who the conspirators are, what the exact object of the conspiracy is, and proceeds essentially on a number of notional conspirators whose identity is inferred from evidence of similar protest up and down the country. But all of this body of law is moving some way away from the usual expectation that people come to court to seek a particular remedy against a particular person for a particular thing. It's also, because it's against everybody, it's also against nobody. And unless you actually are named as a defendant, which may of course bring its own difficulties, you have difficulty being heard to oppose it. In that same injunction, the claimants very much opposed the intervention of somebody who wished to be able to protest entirely lawfully, that said that was her professed position, but didn't wish to become a defendant to the injunction in order simply to say that. And there is, in the judgment of Mrs. Justice Hill, 48 paragraphs dealing with why, in fact, such a person could be heard under CPR Part 40.9. But all that, where does that take us? At the end of it, all that means is that the court will hear someone at their own expense, because, of course, if you're a party, an interested party under CPR 40.9, you can't recover your costs at the end of the exercise of saying this thing should never have been granted in the first place. Now, this Persons Unknown injunction, as I've said, has been expanded and grown. The most recent case, or the most recent authoritative case, is from the most authoritative case from the Supreme Court in the Wolverhampton against Persons Unknown, where local authorities got injunctions to stop travellers coming on their land. The judge at first instance had said this couldn't be done as a final injunction. That was appealed by the various local authorities to the Court of Appeal, which said it could, and it then went to the Supreme Court, where it's known as London Gypsies and Travellers against Wolverhampton Borough Council. And the Supreme Court has essentially said that injunctions of this sort can be granted. They don't actually require an underlying cause of action, because the court will act with a flexible response if it's necessary. Where the balance is going to be drawn is perhaps informed by paragraph 167 of that case, and if you're interested, that's the one to focus on, which sets out a number of limitations that a court should have in mind before granting injunctions of this sort. But bearing in mind that the people who are going to court for these are often going to go ex parte and obviously want their injunction, to what extent those are actually reasoned through to the full extent that the Supreme Court has said should happen in the Wolverhampton case remains to be seen. All of what I'm talking about so far is without any mention of the draconian penalties for breaching an injunction. An injunction is a serious thing. It's the court exercising its authority, saying you shall not do this, and if you do it, you're liable to be committed for contempt of court. You could be sent to prison. You're liable to incur extensive financial penalties through fines and costs orders. And that can happen without you having been involved in the proceedings at all in the first place. Essentially, you become a defendant to the injunction in those circumstances by doing the act that is prohibited. So the first time you may learn of the jeopardy in which you've been placed is when somebody says, we've got this injunction and it stopped you from doing those things. Now, I said how much will
You're reaching the end of your time.
Right. Well, I'll just be very quick with the changes to the criminal law, because the landscape for protesters is also much more serious from Parliament's intervention, deliberately aimed to suppress and deter protest in the Public Order Act 2023. There are now specific criminal offences relating to tunnelling, locking on. You might understand why those might be specific offences, but also obstructing major transport works and interference with key national infrastructure. Well, what is key national infrastructure? You might think that was Windscale or some important nuclear power station or something like that. But in fact, the definition of national infrastructure covers any A or B road. So if you do something protesting on a road that goes beyond the bounds of reasonable use of the road, you are committing an offence for which you could go to prison for a year.
Stephen, I might stop you there and pick up some of these points in questions.
That's fine. That's fine. Yes. Can I just say one thing?
Yep.
Which is that although it used to be the case that the law treated deliberately protesters less harshly because of the intent behind the protest, and there's House of Lords authority to that effect, that has very specifically been changed both by Parliament and by judges and the Court of Appeal in sentencing in recent decisions, and we may get onto that.
We'll pick up some of those points, but I think now, if we could turn to you, Sudhanshu, please, to set out your thoughts on these important issues.
Good evening. Unlike Stephen, I am not, and do not claim to be, an expert on the law of protest. My expertise is in climate law, particularly in some of the recent test cases that have taken place at the international level. For example, in the case of Duarte Agostinho in the European Court of Human Rights, where I acted for the United Kingdom, and in the case of Torres Strait Islanders against Australia in the United Nations Human Rights Committee. The question that I want to consider today is whether, when it comes to protest, is climate change a special case? My contention is that it is a special case, and one realizes that when one has regard to developments of law and practice in other areas of climate law. And furthermore, the English courts are both entitled to and ought to have regard to those other developments when considering these climate cases. I will start by just outlining the human rights framework in which these kinds of climate cases, these protest cases are being decided. Secondly, I want to look at what I regard as some of the relevant developments in other areas of climate law and practice. And finally, I want to return, by way of example, to one of the injunction cases and ask, how might these broader climate factors impact that kind of injunction case? The human rights framework. In these protest cases, The courts, as we have already heard, generally have to consider whether there is a restriction on whether a restriction on the protest, for example, an injunction, is consistent with Article 10 of the ECHR, that is, the right to freedom of expression, and or Article 11, the right to freedom of assembly. This question arises most obviously in the context of injunction cases, but it can also arise in the criminal context, where the defence of lawful excuse is an issue, albeit, as I think Stephen alluded to, the scope for raising that kind of defence has been narrowed somewhat in recent years. Generally, the courts accept that a measure such as an injunction does restrict the protesters' Article 10 and Article 11 rights. The question that then arises is whether that restriction can be justified as being, quote, necessary in a democratic society under the carve-out provisions contained in Article 10.2 and Article 11.2 of the Convention, because Articles 10 and 11 are not absolute rights. They are subject to what is necessary in a democratic society. And in order to decide what is necessary in a democratic society, the courts have to perform a balancing act, trying to decide where a fair balance is to be struck between the legitimate aims of the prevention of disorder and the protection of rights and freedoms of others on one hand, and the requirements of freedom of expression of protesters on the other. In short, the courts have to engage with the question of proportionality. The leading case on this question of proportionality is the Supreme Court judgment in 2021 in the case of Ziegler, which was a criminal case, but where the court considered at some length this idea of balancing Articles 10 and 11 in the context of protest. Ziegler was a case where the defendants were being prosecuted for causing a road to be closed during a protest against an arms fair that was taking place at a conference centre nearby. The court observed that proportionality is ultimately a fact-specific inquiry which requires the evaluation of all circumstances of the case. The divisional court had held that, quote, the long-standing commitment to opposing the arms trade that all four defendants demonstrated was irrelevant to the question of proportionality because it comes perilously close to expressing approval of the viewpoint of the defendants, something which is not appropriate for a neutral court to do in a democratic society. The Supreme Court disagreed with that formulation. In their judgment, Lord Hamblin and Lord Stevens said this. They said, first, whether the defendant believed in the views that they were expressing was relevant to proportionality. But then they went further, stating it is also appropriate to take into account the general character of the views whose expression the convention is being invoked to protect. Political views, unlike tittle-tattle, are particularly worthy of protection. My contention is that when it comes to climate change, the relevant facts and the relevant general character of the views in question should be determined not just by asking the general question, are these political or not, but by drilling in to to developments taking place in relation to climate law more generally. When these developments are examined, it becomes apparent that to a large extent, views of climate protesters are not really views, but they are, or at least are substantially founded on, matters of undisputed fact or matters of opinion that have been universally endorsed, not just by scientists, but by almost every state in the world. So let me then look at these, what I call developments in climate law and practice. Time does not allow me to go into all of this, but I want to highlight four of these. First, there is the 2015 Paris Agreement, which was adopted in December 2015 by over 190 states, including the United Kingdom, at COP21 in Paris. This treaty is the cornerstone of international climate law. The parties to the treaty include the United States and China, the two biggest fossil fuel emitters in the world, as well as countries whose economies depend on exporting fossil fuels, such as Saudi Arabia. The preamble to that treaty, which has been agreed by all these states, states expressly, these states, quote, recognize the need for an effective and progressive response to the urgent threat of climate change on the basis of the best available scientific knowledge. In other words, the proposition that climate change presents an urgent threat is a view, but it is a view that has been endorsed and recognized in a formal treaty by almost every country on the planet, with the exception, I think, of only Iran, Libya, and Yemen. That's my first point, the nature of the views we're talking about. Secondly, the Paris Agreement includes in Article 2 the temperature goal, the objective, which is expressed as follows. The objective of the agreement is holding the increase in global average temperature to well below 2 degrees C above pre-industrial levels and pursuing efforts to limit the temperature increase to 1.5 degrees C above pre-industrial levels, recognizing that this would significantly reduce the risks and impacts of climate change. There's a lot of legal debate I won't go into about the precise legal nature of that provision, but it's there in the treaty. It's a defined temperature goal, again, that these 190 states have come together to agree on. Thirdly, there are the reports of the Intergovernmental Panel on Climate Change. In much of the climate litigation we're seeing that I've been involved with, it's striking that the basic facts of climate change, the causes, i.e. that it's man-made, the nature of the threats, if you go above the relevant temperature goals, none of that is in dispute. And to a large extent, that's down to the reports of the IPCC, which are issued at regular intervals, which are part of a formal UN procedure, which engage multiple scientific disciplines and importantly, which are again endorsed by states. So when we talk about a global scientific consensus, it's again important to recognize we're not just talking about a consensus of scientists, we're talking about a consensus of scientists that has been endorsed again by states. Fourthly, there's the very recent European court decision in the Swiss climate case, Climate Senioren. There are a lot of other climate cases I can mention, but I'm just going to mention this one, which came out earlier this year in April. This was a claim by an association of senior women from Switzerland who argued that their health was being threatened by heat waves, being made worse by climate change, and that accordingly Switzerland was in breach of its Article 2 obligation, that's the right to life, and Article 8, right to family and home. The court found, as a matter of fact, those were its own words, relying amongst other things on the IPCC reports, that there are sufficiently reliable indications that anthropogenic climate change exists, that it poses a serious current and future threat to the enjoyment of human rights under the convention, that states are aware of it and capable of taking measures to address it, that the relevant risks are projected to be lower if temperature is limited to 1.5 degree above pre-industrial levels, and if action is taken urgently, and that current global mitigation efforts are not sufficient to meet the targets. Those were all found as a matter of fact. The court proceeded then to find as a matter of law that the ECHR, when it comes to climate change, should be interpreted in what it called an evolutive manner, in an evolutionary matter, having regard to the scientific evidence about climate change. It found that there is a legal obligation on states under Article 8 to undertake effective measures to reduce fossil fuel emissions with a view to reaching net zero within 3 decades. And they said there are procedural obligations on states which require states to make available procedures through which the views of the public, and in particular the interests of those affected or at risk of being affected by climate regulations or by the absence thereof, can be taken into account in the decision-making process. And then finally, against that background, I want to come back to one of the injunction cases by way of example. So I want to look at an injunction that was granted by on the application of Shell UK oil products. Again, it's a case Stephen mentioned, against persons unknown, to restrain climate change protesters from undertaking activities such as damaging petrol pumps and preventing motorists from entering petrol station forecourts. On the question of Article 10 and 11, the judge who granted the injunction accepted that the injunction interfered with the defendant's rights under Articles 10 and 11, but then he found on the facts the interference was justified. And he said, amongst other things, this. He said, the defendants might say there is an overwhelming global scientific consensus that the business in which the claimant is engaged is contributing to the climate crisis and is thereby putting the world at risk, and that the claimant's interests pale into insignificance by comparison. That is not, however, a weighty factor. Otherwise, judges would find themselves according greater protection to views which they think important. It is not for this court on this application to adjudicate on the important underlying political and policy issues raised by these protests. That is for Parliament. So just against the background of developments in climate that I've outlined, I just want to make the following observations about that approach. First, it doesn't sit that easily with the comments of Lord Hamblin and Lord Stevens and Ziegler that it is relevant when you're doing the balancing act to consider not only whether there was a genuine conviction, a genuine view as to political matters of these protesters, but also to consider the general nature of that view. Secondly, as a matter of fact, the proposition that there is an overwhelming scientific consensus that the fossil fuel trade contributes to the risk of climate and that this puts the world at risk should arguably not be characterized merely as the view of climate protesters, but as I have set out, it should be recognized as a matter that has been endorsed by states, by global consensus of scientists in documents, in a process that again has been endorsed by states, and indeed a view that has been endorsed and upheld by courts, including recently the ECHR. Thirdly, for the UK, in protest cases, for the UK courts to ask a judge to recognise a basic foundation of climate law fact does not mean you are requiring that judge to adjudicate political and policy issues. It is possible for a judge to recognise the kind of factors, the cause and effect of climate that I've outlined as part of the fact-sensitive inquiry, without then having to go further and dabble in difficult issues of UK policy. Fourthly, as a matter of principle, in the light of the Swiss case, the question arises as to whether what the court called its evolutionary or evolutive approach to interpreting the treaty in the context of the question, what are the obligations of states to reduce fossil fuel emissions, whether that same approach now should also be applied in the context of these Article 10, Article 11 protest cases, which also raise fundamental questions around climate. Fifthly, again, as a matter of principle, the Swiss case raises the question about the extent of the procedural safeguards that the ECHR has identified. Are those relevant to the balancing act that the court has to do in the context of climate? Of course, it's open to an English court under Section 2 of the Human Rights Act to not be bound by that decision, but it must at the very least take account of that decision. And just finally, I just want to clarify that the limitation of what I'm saying, I am not suggesting that in every single case where an issue of protest arises, the court should automatically refuse an injunction. I recognise all these cases are heavily fact dependent. What I'm saying is that as part of the weighing exercise, English courts should be prepared to recognise facts of climate change and to recognise broader developments such as the Swiss case, which might or might not make a difference on any particular fact scenario. And then just finally, I just want to say this. I asked at the outset whether climate is a special case. And to answer that, I just want to return to a famous quote from Aaron Jones, 2006 House of Lords judgment, which is often quoted in the context of protest. And the quote starts like this: "My lord, civil disobedience on conscientious grounds has a long and honourable history in this country. People who break the law to affirm their belief in the injustice of a law or government action are sometimes vindicated by history." In summary, climate change is a special case because we do not, to a large extent, need to await the verdict of history in relation to the matters that are subject of climate protest. We already have the verdict of science, and it's a verdict that's been, to a large extent, endorsed by states and is open to courts now to endorse that verdict in their judgments.
Thank you very much, Sudhanshu. That very thought-provoking from both sides. If I can just pick up then a few of the points that I've discerned from you both. Stephen, you are against, quite vociferously, the idea of injunctions against the world, as you put it. I mean, it's not quite right to say they are injunctions against the world, and that anybody sitting in this room might be suddenly in front of a judge unwittingly in relation to a committal application because he or she has wandered onto the national highway when they shouldn't have. The way that the injunctions are framed are very careful. The persons unknown are described, aren't they? They tend to be described as people who intentionally are obstructing the national highways in a manner so as to disrupt the travelling public, and they'll be described in that way. Similarly, in terms of tunnelling or in terms of locking on, there'll be a description of those people, and it'll say that it's somebody who is locking on to the gantry, or they're getting. So it isn't something that you can sort of accidentally fall victim to, and that's the way that the persons unknown jurisdiction has developed, hasn't it? Let me just put a couple more points and then take the questions from you guys. So that's one thing. The second is that these protest rights, I don't think anyone is saying that there shouldn't be the right to protest. I mean, and the same to you, Sudhanshu. The question is that these are qualified rights. They are qualified, and the rights are balanced against the rights that other people may be having in a democratic society. And Sudhanshu, you did touch on that, but I think that you sort of perhaps didn't address this point. You said, well, they are qualified rights, but you said that climate change is a special case. You said, and in this proportionality exercise, you said that, well, judges should be, they shouldn't need to really question the basis of these protests because we know that the climate crisis is a serious one. But isn't there a distinction between knowing the climate crisis is a serious catastrophe and what the government or any government's response to that crisis is? And that's where the problem arises, where you have people taking matters into their own hands, for example, blocking the highway because they want to promote stopping oil, or insulate Britain because they believe that there should be a particular measure taken by the government, or people who are tunnelling under Euston Garden Square because they don't agree with HS2. So is there a distinction there between accepting the climate crisis and what is properly a matter of policy for individual government and how that should be resolved? So just dealing with those 2 points, if I could ask for, I think perhaps Stephen first your response and then yours to the...
Well, you're right in the sense that these things will be formulated so that it covers everybody, but it's people doing a particular thing. But what you don't have until somebody commits you or brings committal proceedings is your opportunity to say that this shouldn't have been granted in these terms in the first place. You can't do that unless you take on a very great risk of being committed for contempt of court.
Yeah, Stephen, is that right though?
Yes.
Because all these injunctions have a right to apply to vary the injunction, don't they?
Yes.
So if you come to know of it and you say, actually, I do want to wander around on the M4 and I want to go around with a flag or a placard, you can go to court, can't you?
But yes, but we're talking about a situation where if somebody's protesting again, you might say that a number of people are planning some protest at some particular place, and place is important, as I said earlier. You know, I mean, there's having the right to protest that allows you to just stand in some car park in Basildon or something isn't as effective as being at the place where the activity that you're objecting to is taking place. So, so if you want to go to a protest and you see other people that you actually may not know, and there's no obligation very clearly to bring any of this to your attention, exactly what is or is not lawful, and these injunctions will, in normal cases, be extending beyond what the criminal law would prohibit. So it's quite common for there to be let's say it's a place injunction, that's something that stops trespass around at a particular place, for there to be some sort of exclusion zone around that place. Yeah. Now, it would, but for the injunction, be lawful to go and stand outside in that place. Now it's not. You've had no opportunity to say that that shouldn't be the case until somebody comes along and says, either arrests you under some sort of power of arrest under the injunction, or brings you before the court in commitment proceedings. So that's what I'm talking. I mean, I accept that that you're unlikely just in. I mean, I think we had this in the Ineos case, where on one reading of it, the injunction prevented people sort of going onto land where they might not have done. And I think Lord Justice anyway, who it was said, well, we're not concerned with dog walkers losing their dog, sort of thing. But that was essentially requiring words to be read in that weren't there. So it's the deterrent effect. It's also the concern over the uncertainty. We often get quite imprecise wording in these things. They're drawn up in a very complicated way, so that although if you sat down and got your 18 pages of injunction, as it may well be, or 37 pages of injunction, or whatever it is, you might, as a top KC, be able to work out what it did and didn't prohibit. These are measures that affect everybody. I mean, going back to some of the things based around there's one of Lord Bingham's judgments on football banning orders, where he said it was important they should be clear, but so that everybody understood it. Giving and to use his words, particularly the defendant in this case, who's not very bright. We don't have that in these. It's all of our rights are being subsumed into something that's unwieldy and complicated, and of itself poses a deterrent even to those who wish to do a protest in a law-abiding way.
Right. I mean, yes. I mean, the difficulty though is in a case like Insulate Britain or Just Stop Oil. They're not corporate bodies, they're disparate set of people who come and go. Yeah. And it's not possible to really know who is going to come tomorrow and to protest. So it's difficult to see another way round it. Otherwise, you're playing whack-a-mole all the time.
Well, those are all issues that need to be thought about in terms of whether it's appropriate to grant an injunction at all. I say the fact that you can't precisely know who the tortfeasor is allows the claimant essentially to invent a sort of bogeyman who's going to come and do all sorts of things. And so on this, what if this happens, or what if that happens, or what if the other happens, it always elevates the risk that is said to be the one that the court needs to restrain by to protect by the rights by injunction, and that's the problem.
Well, let me turn to you then on this question of making climate change a special case.
I agree with you. There is a distinction between the facts as to the climate crisis, some of which I outlined, and the ultimate question of policy, which is what should the government do as a matter of law and policy about it. And that is why I use the phrase a foundation of fact, that these views are based on a foundation of undisputed fact. My point is, looking, for example, at the judgment I looked at, even that foundation of fact is not recognised as a foundation of fact. It's just regarded as another view. And it's in that respect that I'm saying climate is a special case. There are different views that can be taken about what policy should be adopted. But there is a foundation of fact backed by science, endorsed by states, that, on my contention, should be recognised by the courts in their balancing act. That's point one. Point two, I'm not saying that therefore that trumps everything. I'm simply saying that should be a proper part of the process of deciding what I understand are very fact-dependent cases, and it's going to depend on the facts. If it's for example, a case that involves allegations of serious criminal damage, then whatever special facts, special circumstances I might want to argue for climate change, I can see how that case is going to be decided. So that's my position.
Thank you. Well, there'd be many other questions that we could debate here, but I think it's probably time to open up the floor to the audience. And if anyone's got any students, I think first with 30-second questions prepared. There you go.
So this one's for Mr. Swaroop.
Swaroop?
Apologies. So the idea that the weight should be given to the view which is generally widely accepted in the sense of climate change was one of the points you made. But this wouldn't have been the case for certain protests like the LGBTQ protests back in the 80s. It wasn't a widely accepted view. And yet now that's obviously something that we're glad happened. So in that sense, do you think that by putting this requirement would cause an issue for other protests, not just climate change?
Well, I start with a bit of a cop-out, emphasising I'm not a protest lawyer, and I'm certainly not an expert on the issues that you've raised. I don't think my approach would cause an issue for those sorts of cases, simply because I'm not suggesting that those cases should be treated any worse than they are currently treated. I'm simply making a very specific point based on the facts of climate change, that there is a case based on fact and science for there to be a foundation of fact when judges do the weighing exercise. Whether similar considerations could be applied outside of that context, I'm not going to try and go down that road today.
Can I just say that it's a very interesting point being raised, and this is the sort of point that's made in a number of the protest cases, and you might want to look at national highways and persons unknown, where the judge made exactly this point. He said that the right to protest is the right to protest whether it's a good point or a bad point, and he said that it would be wrong for me to express either agreement or disagreement with those views. Many of the submissions made to me consisted of an invitation with me to agree with the defendant's views and to decide the case on that basis. That is something which I cannot do, just as I could not decide this case on the basis of disagreement with their views. So it's a valid point, I think, that the actual issue, the courts at least don't think should be given weight, because the issue of protest is one that you should be able to make regardless.
Thank you. It's a question to both speakers today. There seems to be a big discrepancy between how international bodies interpret right to protest and domestic law does. So for instance, under ICCPR, derogations are only allowed in cases of national emergencies, threats to public health, etc. And here we heard about injunctions just in fear of nuisance. Why is there such a discrepancy? Where does it come from, and how is it allowed under international law?
Well, I mean, the cases we've been looking at are to a large extent based on a form of international law, which is the ECHR, and the balancing exercise in Articles 10 and 11. And I mean, what you can express views about whether a particular case could have gone a different way, but ultimately the judges in those cases are applying or seeking to apply established ECHR jurisprudence under Articles 10 and 11. So then I guess the question is there a distinction between the ITCPR and Articles 10 and 11 in relation to protest? I'm afraid I don't know enough about ITCPR jurisprudence on protest to take a view on that. I know, Stephen.
Do you have any? No? Something for another day then.
Good evening. Recent times have witnessed a sharp decline in ESG funds. I want to know how that would affect environmental regulations and also the ability of protesters to protest.
When you say ESG points, could you just clarify that, please?
Like funding from companies, like big companies, let's say like BlackRock or other huge investment companies, which have committed a lot towards ESG or in the last 5 years, have either shut down a lot of their funds or reduced the size of their funds towards the ESG causes. So how would that affect environmental regulation? And also, what impact would that have on protesters' right to protest and mobilize support for their environmental causes?
I think these are broader questions around environmental regulation, rather than the right to protest. I mean, I think what you say, the premise of what you say, as I understand, is correct, that there's a bit of there's a rollback, there's a retreat from ESG from where we were 3 years ago. And I can see how that would affect the general ability of people to advance, say, a climate change agenda in the public space. But I'm not sure that it would necessarily affect the right to protest as a legal right.
Like it would cut down funding in the first place.
Yes, I mean, it might then affect the ability to mount effective protest, but looking at the legal characterization of that, which I think is what we're focusing on today, I'm not sure it would impact. I mean, Stephen, what would you say?
I agree with that. Yeah, I agree with that. I don't think I've got anything to add on that point. I mean, I think these companies don't expect their ESG funds to be used to fund protests against them. Yeah, on what we're talking about, I think that's probably for another day.
Yeah, I mean, just one observation. I can see a link, for example, where you have the phenomenon we've had in the last 2 or 3 years of, say, NGOs buying shares in companies in order to be able either to turn up at company AGMs as a shareholder and propose shareholder resolutions that favour action on climate change, or in the Client Earth Shell case, actually bring derivative actions against companies. I can see that as part of that retreat from ESG, companies may become less willing to engage with that kind of initiative, and indeed more combative when those kind of tactics are tried. So that's just an observation.
Thank you. There are quite a few questions online, so I'll take one of those. I think. I mean, this is a sort of a rhetorical question, I think, but probably worth just perhaps picking up. It says the suffragettes attacked a Veloquez with a meat cleaver, and now we have a statue of a suffragette in Parliament Square. In 100 years' time, will we have statues of Just Stop Oil's soup throwers? So how will history judge this issue? I think I know what you're going to say.
Well, we don't know how these things are going to play out, but the fundamental point is that in this country we have a tradition, for good or for ill, of disruptive protest actually making a difference to how things are. Even a few decades later. I mean, it's in my adult lifetime that the apartheid system has come to an end in South Africa. It's not that long ago. I'm not that old, so it's and things that seemed and people protesting against them. I've mentioned the people at sporting events. I mean, there were people being arrested and fined by the British police for the protests outside South Africa House down at Trafalgar Square, all through the 80s and 70s and so on. It was a whereas now the idea that anybody in this room would think it would be wrong to protest against a country that formalizes racial discrimination of the sort in the way that South Africa did, it would just not be understood.
Yeah, I just add to that a bit, to general comments in the context of climate change. It's interesting, in the Swiss ECHR case that I mentioned, one of the factors the court emphasized was the notion of intergenerational justice, that it is necessary for states now not only to take effective measures, but to take them swiftly, because to do otherwise would be to impose an unfair burden on future generations. And certainly on the projections of the science, the impacts of climate change are going to become more and more apparent in coming years. So to go back to the question, those who are currently protesting climate change may not receive a universally favourable audience, but it is certainly conceivable that, given this idea of those who are young today will be really on the receiving end of this stuff in the next 30, 40 years, that they will be the ones making this judgment about whether to erect statues, and they may well look back at this time and say, well, not enough was done to protect us when we were young in 2024.
somewhat following from that, I guess, my question is, do you think that there's an impact on the fact that much of the historical places and experiences you're talking about were against governments, and what we're talking about now is against corporate and private industry? I mean, it's petrol stations and, and the like, not the South African government, for example, and that the restriction on protest, the injunctions and such, are partly happening because that's who is on the other side.
Yeah, I mean, that's an interesting point to make. Essentially, what we have is the essentially privatization of the regulation of protest, and that's in a number of ways. I mean, the definitions of key national infrastructure, I've mentioned A and B roads. Obviously, those are public highways and so on, but things that are run by a number of newspaper printing infrastructure, that's all private businesses. The harbour infrastructure, many of those are in private hands. So there is a sort of commercial benefit to some of these companies having injunctions. I mean, one of the cases I did, I was looking at how the share price of the company changed according to when we went to court and how well they did. And I mean, that's one of the considerations. To some extent, an injunction is a bit like a quasi-proprietary right. I've got this nice handbag. Would you like this nice injunction to come with this plot of land? And it's there is a commercial value, and what we're in some ways talking about is the protection of people's commercial interests over and above the objections of other people.
Yeah, I've got nothing else to add on that.
As budding lawyers, I would say we're concerned about how we can use the courts for enforcement purposes. And I guess I have two questions on how this enforcement can be actualized. My first question is, could we use the same line of reasoning used in the boogeyman injunctions that you spoke about, but in the other direction, where we could bring injunctions against any form of polluting, against any polluting actors? That's my first question. And my second question, following on from these discussions on protecting commercial interests and how we can go against private industry, how can we incorporate all these grand legal sets of reasoning between large companies under contractual provisions? Is there room to bring real environmental enforcement regimes through contracts from a commercial perspective?
Let's deal with your first question, the question about whether it's possible to obtain injunctions against fossil fuel emitting corporations. Well, the leading case on this is the one that I mentioned. It's Milieu Defensie against Shell in the Hague District Court. In 2021, the Hague District Court granted what we would recognize as a mandatory injunction against Shell, ordering it to reduce its global fossil fuel emissions by 45% by the year 2030 across its global supply chain. And it did that on the basis of a two-line bit of Dutch tort law that says something like, to do that which is contrary to the generally accepted way of doing things is unlawful. And they read that together with ECHR and so on, and came up with this incredible order. Now, when I was a law student many years ago, the idea that you could go into any court anywhere and get that kind of order against one of the world's major oil companies was unthinkable, and it perhaps reflects a change in judicial attitudes. I mean, my own personal theory is it also reflects a change in attitudes amongst Dutch judges, being from a country which one of the most obviously threatened countries by climate change. It perhaps concentrates the judicial mind if you're writing a judgment with the North Sea lapping away just 100 meters. or so.
Figure in the dike.
Or so down the road. So that's the civil law, and there are people trying to repeat that. In the common law, the leading case is going through the New Zealand courts, a case called Smith and Frontera, where Mr. Smith has tried to get injunctive relief against various New Zealand energy companies based on the common law torts of nuisance and negligence, and what he describes as a new common law tort of contributing to climate change. And that's gone to the New Zealand Supreme Court, who've, on a strikeout application, they've held that these torts are sufficiently arguable for the case to go forward to a full trial. So the answer is, from a common law perspective, look out for what goes on in New Zealand, because that will no doubt inform what might be possible in this jurisdiction. That's what I've got to say here. Yeah.
Thank you. There's one there, I think.
Thank you. My question was primarily to you, Sudhanshu, about the exception of climate change. And I was wondering whether your position is really that climate change constitutes an exception, or really that it should just be recognized as having a factual basis and therefore treated like any other fact, which would make it not so much exceptional as simply based in fact.
Yeah, I think maybe the way you put it is a more elegant and analytically correct way. I think what I was trying to perhaps say something for rhetorical effect, but I think what the way you put it is perhaps a more accurate way of explaining what I'm saying. Yeah.
Two at the back there.
I want to follow up on your comment about judges' attitudes. What do you think is the likelihood of adopting a more pro-rights and pro-climate change approach? How much resistance or backlash would it receive from Parliament? And or is the narrowing of protest rights predominantly a consequence of the court's conservative approach?
Is your question specifically about protest rights, or is it about climate change in general? So climate change more in general? Yeah. Okay. Well, I mean, the premise of the question is that UK courts have not already handed down judgments which are pro-climate change, and it all depends on the context. But for example, in one of the challenges brought by the Good Law Project, year and a half ago, which was a judicial review of the UK government's climate policies. It was said that those climate policies were not consistent with the government's obligations under the Climate Change Act. Mr. Justice Holgate, I think it was, gave a very detailed judgment and said, yes, in various respects, even taking account the very high threshold for judicial review, the government hasn't done enough. And that's an ongoing process in that litigation. There have been other examples. For example, the Client Earth Shell case about directors' duties failed. So I don't think it's possible to draw some general conclusion that judges are or are not being conservative. It's going to depend on A, the particular context, and B, also the particular judge. What I do think is different now to certainly 10 years ago is from the perspective of counsel. My sense is barristers, advocates are bolder, are more prepared to go into court and raise issues about climate change, which 10 years ago would have failed, 22 years ago might have got a wasted costs order against you. That is that. And also I think judges, whatever ultimate judgment they give, they know that if it's about climate change, they need to treat this seriously, because there's going to be a lot of people reading this very carefully. So I think that's changed. I don't think you can draw that kind of generalization.
Yeah, just to add to that as well, I think it depends also on the type of challenge that's being brought and whether or not there's a hook in policy or law that you can bring your claim on. So, for example, in lots of land use planning cases, climate change policies are embedded in local plans and in statutes. So there would be a basis for bringing a challenge if the relevant public body, for example, ignored those requirements, or even if a public utility company did that, because there are various obligations. So yes, I mean, I agree. I don't think there is any reluctance by judges or the courts, but there has to be a hook And I suppose that's the difference in these protest cases, where there isn't really the hook. It's the sort of catastrophe as a whole that's being concerned with. We have got time just for really probably maybe let's say two more questions.
Well, the chap on the end had his hand up for a long time. It keeps being missed by the mic.
It's okay. Something you see cited quite regularly is the risk to life and safety as a counterweight to Articles 10 and 11, both in public political discourse and also in legal cases, I think. To what extent do you find that personally convincing? And to what extent do you think, and how do you think judges should balance those interests, one against the other?
Yeah, I mean, there are obviously some things that some people do that are extremely dangerous and difficult. I mean, in one of the difficulties when you've got people who, as it were, don't want to put their hand up to say, I want to oppose this injunction, is you end up with people in the situation I've said of people who are there because they've been committed for contempt of court. I turned up at one of these, and one of the people involved had broken into the oil refinery and started sort of turning off the taps and stuff, which was an extremely dangerous thing to do. So it was sort of obviously you can see why somebody might want to stop people doing that and want the protection of the courts to do that. But on by the same token, the protester had seen it as a way of making his point, actually taking very direct action, turning it off. But there are some of the things that people do. Essentially, they're putting their bodies on the line, aren't they? They're putting their own lives on the line, and the question that has to be considered by the courts, and it is a valid and important question, is the balance that is struck between the rights of others, which is what the end of the title of we've all been asked to address is concerned of, and the responsibilities of the court to people themselves who may end up doing things that are ill-advised or dangerous or put their own safety at risk. I mean, Emily Davison died under the King's horse. It may be that she believed in the cause to that extent of women's suffrage, but I don't think anybody would say it was an entirely neutral thing that she was doing when she undertook such an extreme protest. So obviously, lives and safety are always going to be paramount considerations, and you can easily understand how some things that people either might think about doing or actually have done would be the wrong side of any line that anybody was trying to draw. But my concern is that we don't, by fearing too much that people will do that sort of thing, that we end up cutting back on things that ought to be allowed or tolerated or dealt with much less harshly than by being found in contempt of court or by being sent to prison for a number of years.
Yeah, I mean, I think that is what happened, though, just picking up the point in relation to the Public Order Act, because tunnelling now is especially mentioned as something that is forbidden. But that came about along with the locking on and disrupting infrastructure because of the very extreme case of children and young people tunnelling under Euston Garden Square to prevent HS2 proceeding. And that very much puts people's lives at risk and put the rescuers' lives at risk. And it's interesting that it's all of those protests that are now reflected in what could be seen as quite a draconian act, I think, the changes in the Public Order Act. But they do reflect all of those sort of situations which are dangerous, tunnelling, locking on, and disrupting infrastructure.
Oh, yes, but obstructing a B road may not be in the same category.
Well, if it's going to cause a huge economic loss, obstructing ambulances, obstructing people getting on with their lives, could do.
I'm just saying. I'm just saying the same act
Yeah.
introduced that prohibition, and it's a long way different from prohibiting tunnelling under Euston Square.
Right. I think we probably just got time for one more, two more, and one more online as well. Yes.
Hi, thank you. So I'm interested in this point about the legitimacy of injunctions against persons unknown where there's no underlying cause of action. And obviously that's a technical point, and I'm wondering whether your objection is whether those injunctions are legitimate in any context, or whether you think there could be an exception for climate protests, because I think they're intuitively much more acceptable where that case was developed, in terms of IP breaches and the Bloomsbury case or the Carter International. Even in Wolverhampton itself, I think on the facts of that case, it's quite sympathetic with the councils, where there's no way of enforcing because the travelling communities continually are moving. And then would there not be an argument that, well, why would the property of certain landholders be treated differently if we're not saying if other categories of property or real property itself, we are going to enforce this in other contexts, but just if the landholder happens to be in a certain industry, we won't have this jurisdiction.
No, I understand the point, and part of the concern is the need for if you're going to grant an injunction, you have to be prepared to enforce it. Because you're prepared to enforce it, it has to be clear. And if it's not clear, it either poses an unacceptable deterrent to those who are put off by not wanting to break the law, or it just becomes so unwieldy it collapses under its own weight. I can see the conceptual distinction between rights of property, whether it's intellectual property in the Bloomsbury cases about the person. There was a Harry Potter manuscript. It's just we didn't know who, or nobody knew who it was who nicked it and was trying to publish it ahead of its lawful publication. In some of these injunction cases, we know where the Shell Tower is, and we know that we can see that it has an edge, and this is their land, this isn't their land. That prohibiting people going onto land or doing things that clearly interfere with an identifiable right of property is perhaps easier for a court to draw up a prohibition than some of these other things. I mean, my concern particularly is around the sort of abstract nature of claims such as conspiracy to injure. I mean, in the Ineos injunction, they had a claim in conspiracy to injure based on all sorts of people that could move in and out of a list of protected persons according to what they were doing that day, whether they were at one particular. But you'd have no real idea whether what you were doing was actually, allowed or not, depending on what the purpose of the act was, and so on. And so that is a different category of uncertainty from what you're talking about. But I understand your point that that if you essentially a person's unknown injunction in trespass turns the old sort of legal fiction, trespassers will be prosecuted, doesn't mean anything, into it does mean something. Don't come here or you'll be in contempt of court.
Thank you. So if I take one from the online, it's an anonymous attendee, says this: if the courts take the view that climate change is a matter of fact, how do we balance the rights, Article 10, 11, of those who do not hold a view that climate change is real? How can the courts both take the view that climate change is a factual matter and the right to protest against climate change, particularly where this protest is a disruptive one, without possibly punishing unduly, in comparison to climate activists, those who may come from less fortunate and educated backgrounds? Right. Interesting one.
Yeah, I'm happy to meet Anonymous and have a drink with them and discuss that. Yeah.
Yes, draw chocolate. Yeah.
But before I express our thanks, Sir Jeffrey's asked me to read out something he meant to add at the beginning, which is that there is a reading list compiled by the library on this topic, for which many thanks, and that will be circulated with the video recording and available on the Inn's website from tomorrow. I do greatly wish to thank the panel, including the moderator, for a superbly crafted evening, which has been absolutely fascinating on this extremely important topic. I am going to make deliberately no comment whatsoever on the issues which arise. First, because I am a judge, but also because, as a judge, I have been involved in the last 18 months in quite a number of these cases over the road in the High Court, hearing applications without notice and with notice on return dates for injunctions, and then a number, 50 people or so over a period of many days, hearing applications to commit individuals said to be in breach of those injunctions. So I will say no more. I simply waited with a mixture of relief and disappointment as to whether or not I would have any of my remarks quoted back at me in cases the title of which I was familiar. But I would simply make 2 points more broadly. First, this seminar tonight reflects the importance which the courts attach to these issues. These matters are not dealt with by rubber stamps or anything like it. These applications are invariably in London heard by a full-time High Court judge. Applications without notice are not listed for minutes. They may well have a hearing allocated of 2 hours or so. There will then be further applications in court, usually in court rather than on paper, on issues like substituted service. So the importance is understood and is very, all judges dealing with this, I know from direct experience, are conscious of the issues which arise. One of the consequences is there are now quite a substantial number of long judgments given by individual judges who have been dealing and wrestling with all these points which many could have yet to be determined at higher levels. But the second point I want to make is about the role of the bar in this whole process. In the course of the speeches I have given at call night, really the most important night of the year in many ways, within the Inn, I have sought to emphasize the ethical duties of barristers, of integrity and courage. Integrity, fairness in every way, honesty in every way, and courage in being fearless as counsel to present arguments which may be on the face of them unattractive, or for unattractive people and have to be pursued in either direction. I have to say that one of the most gratifying features of the many hearings I have had in this area in the last 18 months has been first the very fair, properly fair presentation by counsel for the claimant for private companies as well as public bodies in presenting their case, first at the without notice hearings, and then of course very importantly on committal committal hearings, and secondly the really superb advocacy from counsel instructed by the defendants. Legal aid is not available to respond to injunctions or to set aside injunctions, but it is fortunately available on committal proceedings. And I have had the privilege of listening to robust, extremely well informed and presented advocacy from a council on all the points that are there to be taken. And it is a mark of the bar's continuing sense of both integrity and courage that is the case, and I am extremely grateful for it. And in a dangerous world, I find it a reassurance in this country, whatever the disadvantages in our system, that we have that form of ethical standard in all the debates that take place in court. That high standard has, of course, been replicated this evening by all the participants in it. It has been fascinating from the point of view of the law of protest, from the law of view of climate change, and from all the interventions and observations made through the moderator as well, to listen to these arguments and the balance which arises and the issues which arise. We are extremely grateful for all your work in putting together these talks. They all take time in the course of very busy practices. Thank you very much indeed.
Thank you.